How do you challenge the breathalyzer evidence to win your DUI case in Ontario? That's what I'm going to cover in this video. I'm Dan Joffe, DUI lawyer at Nextlaw. Let's get started. One of the most common DUI charges in Ontario is known as the over 80 charge. That means you registered a blood alcohol reading of more than 80 milligrams of alcohol per 100 milliliters of blood. The Crown lawyers prosecuting your over 80 charge will use these breath readings to convict you of your DUI. A common way for DUI lawyers to beat your over 80 charge is to challenge the integrity of your breathalyzer or intoxilyzer results. Here are some of those arguments. 1. Observation period not correctly followed. The breath technician must observe you before administering your breath tests. During this time, they have to ensure that you have nothing in your mouth, such as gum or food, that you are not drinking any fluids, and that there is no belching or regurgitating of anything from your stomach. Failure to properly observe you during this observation period would undermine the credibility of the breath results and potentially exclude those readings from your DUI case. Without the breath readings, the Crown's case against you would be significantly undermined. 2. Technician error. The reality in life is that people make mistakes in their job. That too applies to breath technicians. To determine whether a mistake was made during setting up, calibrating, and gathering breath samples, you need to dive deeply into the evidence you get from the Crown. If mistakes were made, then the credibility of your breath readings will be compromised and your case may be withdrawn. 3. Breaching your right to speak with a lawyer. When the police arrest you for a DUI in Ontario, they must follow the rules in the Charter of Rights and Freedoms. One of the rules in the Charter is that on arrest, you have a right to speak to a lawyer. Although that rule seems straightforward, there have been many court cases that have further defined what this rule means. For example, if the police overheard your conversation, that would violate your constitutional right to speak with a lawyer. Alternatively, if you already have a criminal lawyer and the police did not attempt to contact your lawyer, that would be a breach of your rights. And if there are many more examples. So if your right to speak with a lawyer was violated, then it's possible your case would be withdrawn even if your breathalyzer readings were valid. 4. No reasonable or probable grounds. Another rule in the Charter of Rights covers when the police can arrest you. For the police to arrest you, they need to have reasonable and probable grounds to believe you were impaired while driving. This can include poor driving, slurred speech, or lack of coordination. But just because an officer smells alcohol in your car or sees that your eyes are red, it doesn't necessarily mean that you are drunk driving. In the event that the police are unable to prove a proper legal reason for arresting you, then the results of your breath test may not be admissible evidence. Finally, if you've been charged with drunk driving, DUI, impaired driving, or refusing a breathalyzer test, your legal strategy can make the difference between winning and losing. Reach out, let's have a confidential conversation about your case. The call is free and you can book a time by clicking on the link in the description below.